So the procedure for this is, as you can see on the shared screen, there's a number of themes of questions that we'll be speaking to. Last I looked, from last evening and today, we had over 250 questions. I didn't get the final tally. And of course, people will pile on with all sorts of questions today. And it'll be on these topics in general. And you can see that we have staff, part of the team muted here. There's Jennifer on the top. She works with wills and trusts most primarily. Victoria will be the moderator. She works primarily with tax credits and other supportive work on a number of files. There's Diane. Diane's my associate lawyer. She does a lot of legal guardianship and probate work and inter vivos trust work, various things. You see Karen. Karen does primarily the benefit increases and tax work and anything else that's needed to expedite the turning of the world. And I'll just show you briefly a couple of statistical considerations. You can see here that this is the number of people on ODSP in the province of Ontario. And if you look at the number of households, StatsCan says you divide by 3, so you take the population and divide by 3. And intuitively, you might think, well, okay, that's the number of households. So that's a good approximation that there's this number, 4,566,000 households. But you can see here similarly that there's 378,000 people on ODSP, they're children. And this number doesn't include kids under 18 or the children over 65, which is a demographic, baby boom kids, right? So it's easily one family in 10 that is a parent household of a child with special needs. And this is a rough breakdown of the types of disabilities that people on ODSP have. Now, I don't see a category here for autism. I'm not quite sure where that would fall into, what part of the pie that would fall into. And we'll be speaking about various things. We'll be talking about benefit increases. How do you qualify for ODSP? We'll touch a bit on the caregiver benefit. This is the COVID-related benefit. How do you get approved for the disability credit? What is the caregiver tax credit? These are the tax credits that we typically find that people aren't using, should be using, didn't use. And we backfile them for 10 years in most cases. And because they didn't know about them or didn't use them. And recapture $16,000 here and $10,000 there. We'll talk briefly about RDSPs and how big they can get. We'll talk about the differences of guardianship and powers of attorney. That'll be Diane. So all of these things, these are where the questions will come in. And at the end of the day, you'll probably still have more questions. So these are the people that you'll be sending those questions to, dealing with the topics that I've just discussed. So you'll see as we proceed that people will speak to the work they do every day. So that being said, I'd like to welcome everyone. We have 115 people, so that's almost exactly half. So we're all ready to go at 7 minutes after. Now, Victoria, would you like to lead off with a typical question to pose for people? You have a list of questions to delegate, I believe, don't you?
Yes. So I can start off with an ODSP question. Marie sent this one in. It's how much money can a person with disability have in their savings account before their ODSP is cut off? Diane, do you want to answer this one?
No, I'll answer that one. The asset test is $40,000 of all sorts of monetary assets, not cars, not houses, not boats. And the gift rule is $10,000 over 12 months. Next.
This next question is about the tax credits. It's from Shauna. Her question is, we are divorced parents with an adult child in a group home. Which parent should be claiming the disability tax credit, and does this require a court resolution?
Who wants to try that one? Want me to do that one? Or? Well, there's no court resolution. That's not necessary. One of the curiosities is that the child support paying parent can't use the disability tax credit. Why that is, I have no idea. Same thing for the caregiver credit. No, just why it is that a support paying parent who clearly helps with food, shelter, clothing for the child can't receive the transfer of the disability credit when it's abundantly clear and by order or agreement they are helping with food, shelter, clothing, that they can't use it. I don't understand the historical purpose of this. So that means that although it could be traded back and forth, if there's no child support being paid, you can't split it, but you can pass it back and forth if you wish, or as part of your arrangement, agree that one party is going to use it, and this is part of the overall consideration for the parties of why they made the deal that they did. That's it.
All right, well, while we're talking about the tax credits, we have another tax credit question from Lucy. The question is, what do I do if my doctor refuses to complete the disability tax credit form?
Karen, do you want to speak to that, or do you want me to answer it?
Oh, if you can answer that, Ken, I'm just sending question answers.
Okay, I'll do that.
Thanks.
It's a common problem where, there's an old saying that, do you know the difference between a doctor and God? And the answer is, God doesn't think he's a doctor. So what it comes down to is that there are certain doctors who prejudge their ability to determine what Canada Revenue will accept. And I'd like to suggest that I have more experience with these matters than the doctor does, frankly. So we'll be the ones to decide. Or if the doctor does in fact refuse, which happens, they won't qualify. I've heard that one. Then we find another doctor, or we have registered nurse practitioners who could fill out the T2201. You then get into the question of, well, how do you deal with the backdating of the form? Well, you either get the records, or once it's approved, I'm just talking tactics here, perhaps then you go back to that doctor who said that they wouldn't qualify and say, well, they are qualified and they've had these same behaviors since age 3. Would you mind confirming that they've had these same behaviors and restrictions since age 3? And it's purely tactical. Lots of times doctors retire. The one doctor that you've had for the child all their life after age 18, they're now retired. This is common, right? So what do you do? These are just typical problems. And the work that we do on the tax credit work it's a contingent fee. So if we don't succeed, there's no fee. So it's a practical, interesting discussion, but it's not really the client's problem. Next.
So this one is a Henson Trust question for Jennifer, and it's from Rosalind. Her question is, how can I create a Henson Trust if I don't trust anyone to have control over my money?
Yeah.
Hi, Rosalind. Excuse me. Hi, Rosalind. Thank you for your question. Now, can you actually repeat the question again?
Sure. It is, how can I create a Henson Trust if I don't trust anyone to have control over my money?
We discussed this the other day, John. This is the same one.
Okay, so what if you don't have anyone within your family grouping that you don't trust to manage the money of the Henson Trust? There are a couple options available to you. First of all is the the trust company arms of the major banks, like for example, Royal Bank, CIBC, TD, for example, and there are also private trust companies such as Concentra, who will manage the money of the beneficiary. They are a neutral party. They don't have with the family history in dealing. They don't have to deal with the family history, and they just simply have that absolute and unfettered discretion to disperse funds to the beneficiary.
What I want to know about that question, it wasn't clear to me, and perhaps the person asking it can clarify in the boxes, in the questions. Is this a person who's going to be a beneficiary of that trust and doesn't trust anyone? Or is it the parent who just doesn't have anyone they can trust, which is legitimate, to act as trustee? That's the part I didn't understand about the question. I don't want to speak further about it, but if the person that asked that question could enlighten me, I'd appreciate it. Next.
So another question, this one's from Lorraine. What are the benefits of setting up an annuity versus a Henson Trust, and how much can a person withdraw yearly from a Henson Trust?
Is that for Jen or for me?
That one is for you.
Okay. Well, they're not in opposition, but to do both, if you decided to do both, to both have a trust and also have an annuity. And an annuity, by the way, is an insurance product where you settle a certain amount of money, let's just say $100,000 on the insurance company, and they promise to pay, and they will pay. They're insured. All of your capital back over the period of your lifetime, plus some small amount of interest. And it's a guaranteed payment. There's no question about it. And you can have a guaranteed period. So you wouldn't want it to end when you die. You wouldn't want to fork over 100 grand and die the next day and have nothing left. So what you do is you build in a guarantee period. It pays for life if that's the type you buy, but you build in a guarantee period of what we do is a guarantee period that will ensure the repayment of the total, at least of the capital. So for simplicity, suppose you put you're given your age and you put $100,000, you're 61 and you put $100,000 into it. Well, if it paid for the balance of your life, it might pay $183 a month. So if what you want to do is make sure that someone gets back all of your capital, what you do is you put a guarantee period on it such that it's 183 times 12 times the number of years that it would take to at least repay the capital. But the purpose of annuities, in some cases, is where the beneficiary is just a known pain in the butt. And it's not the managing of the money, it's not the investing of the money, it's not even really the dispersing of the money. It's that the beneficiary is so hard to work with that it's just not worth the grief and the calls at 11:30. So in some cases, especially when it's a modest amount for a trust, like 100 or 200,000, you couldn't give the money to the person, even if you could exempt it in various ways so they don't lose ODSP, because we do a lot of that. Lots of people die with no trust, but it allows you to set up this annuity and you're done. And from then on, that person receives this much a month into their bank account forever, and you're done. So it's not either or necessarily, but it's often an alternative to otherwise setting up a small Henson Trust and having annual tax filings and the fees involved and dealing with an aggravating beneficiary. I think I probably gave you too much information there. Okay, carry on.
All right, this next question is for Jennifer, and this is from Jamie. Question is, what is the difference between an inter vivus and testamentary trusts?
In a nutshell, an inter vivus trust is an arrangement that is made between two living persons, and a testamentary trust is a trust provision that is written into a will, and commonly Henson Trusts are testamentary trusts. So.
And this next question is for Ken. It's from Colin. This question is, what happens with a Henson Trust upon the passing away of the individuals who funded it?
Well, that's when the testamentary trust comes into play. What happens is the parents die, the second of the parents dies, and the share of the estate that is to go to the child with special needs doesn't go to them directly, but goes to the trustee of the Henson Trust to invest and manage and disperse according to the beneficiary's needs. And then if what you really mean is what happens when the beneficiary dies, well, the trust has a distribution clause that provides who gets what's left. And it's normally their children, if any, or their siblings, or the siblings' children, but it could include charities. It's directed by the testator, the deceased parent. There are rare occasions where it's appropriate to have that distribution provision, but say that if the beneficiary, who being of sound mind but some physical disability, that if they have a will to distribute pursuant to the terms of their will, it could do. But normally it's all directed by the parent who settles whose estate settles the trust.
Great. This next question is for Diane. It's about legal guardianship and power of attorney. From Clive, he asks, what is the difference between legal guardianship and a power of attorney?
Hi, Clive. That's a very good question. There's a lot of differences. I'm just going to talk about the common and big differences. One is capacity. So if the person doesn't have capacity to make decisions for themselves, then you're definitely going to go with guardianship. If they do have the capacity to make decisions for themselves, but they want to maybe just appoint a substitute decision maker when they're not available or they're sick, then you would go with a power of attorney document. There is a large difference in the type of how many documents you need to complete this appointment. For the power of attorney document, it's typically 2 to 5 pages. For guardianship, there's various ways to appoint a guardian. One is through court. It could be through the statute. Well, those are the two main ways. But if you have any more questions, feel free to send me an email. My email is my name, Diane, DIANNE, @kpopla.ca.
Thank you, Diane. This is another question for you. This one is from Arnie, and he's asking, how do we get continuity of legal guardianship after the parents die? How do we have another family member become a new guardian?
Hi, Arnie. That's also a good question. So usually when clients come to us and they're looking for guardianship, they're also looking for what you're asking for, and that's continuity. So usually we have more than one applicant. So it would probably be maybe the parents and the oldest sibling, or parents and a younger aunt or cousin. Because if you don't, if you only have one guardian and that person passes away, then the guardianship is terminated. And in order for someone else to come and take hold of the guardianship, they would have to go through the process again and apply through the court. And so in order for the client to bypass this second guardianship when the first person passes away, we have those applicants normally apply all at the same time.
This next question is for Ken. It's from Andrea. She says, I am a trustee. The bank says I also need a power of attorney to make decisions with the RDSP. Is this true?
That's true. Yeah, the RDSP is the property of the person who I presume is the beneficiary of the trust. The trustee administers the trust asset, which is an inherited asset, which doesn't belong to the beneficiary. It's just held for them. The RDSP, though, does, of course, belong to the person who qualifies for the disability tax credit. So to administer that, if they're competent, you'd have to have their power of attorney to become an account holder with them to help them invest. One presumes that the people who have never had any kind of serious money before are financially unsophisticated. They haven't learned a lot of financial literacy. This isn't a put down, this is just a fact. You have to have something to play with before you learn how to handle money. You can read, I guess, but you still have to. It's like when you go to the, I went to the casino once across Lac Limi, and they have a kids room there. That's not really a kids room, but they have a penny slot machine room where you can learn with pennies. They give you the pennies how to play their slot machines. Sort of like training wheels, So it's like that. You could read about it, but you at least have to play with tokens to learn how the game goes. And yes, you'd have to have power of attorney for property to be able to be the account holder. That's the simplest route. And then you can help make investment decisions. Properly made, just to give this context, properly made, you can see here that if an RDSP is set up and normal contributions are made from age 18, and it's invested at 5%, which is feasible, and you make contributions for 20 years, up to 2040, and then you leave it all invested at 5%. By the time the child turns 60, it's about $700,000 if you've invested it prudently at 5%. And it then starts to pay out $30,000 a year over a 23-year period. So this is why it's critical that you properly invest the money. And quite often you'll find that if you have an RDSP set up at a bank, well, there's a natural conflict between you and the bank, because the less interest you make on that RDSP, the more interest they make when they lend that money out. So you need proper advice on how to invest it. If you can get that through an advisor at a bank, more power to you. But otherwise, you should deal with someone who's interested, whose interests are in alignment with your own, a financial advisor who wants to see more growth, success, future funds. And unless you have the right advisor at a bank, you're not going to get that.
While we are talking about RDSPs, we have a question from Patricia, and it is, can a person receiving an RDSP invest in tax-free savings? Ken, did you want to answer that one?
Can a person who has an RDSP invest in a tax-free savings account? Oh, certainly. The RDSP is a separate exempt asset, no matter how much it is. Bearing in mind, of course, that the first two letters of a tax-free savings account, TFSA, stand for tax-free. And people who are solely on RDSP don't pay taxes. Now, that doesn't mean there's anything wrong with having a TFSA, but it wouldn't be most of value when you turn 65 and you're not on ODSP. And if you had income, for every dollar of income, you'd lose 50 cents if you guaranteed income supplement. So it certainly becomes important at age 65. But if you decided to set up a TFSA, you certainly could. And as long as you keep in mind that the TFSA plus your bank account and whatever other liquid assets you might have to stay below the $40,000 personal asset test. So one hopes the TFSA will be invested and grow, but you got to keep it below 40. Now, we do have a way of letting it grow to a further 100,000, 140,000 if you wish, but that would take more discussion than I have time for here.
This next question is for Jennifer, and it's from Michelle. She's asking, how can I create a will for a person with a disability who does not have a cognitive understanding of money or what a will is? What alternatives are there to ensure their assets are passed on to family and not the government?
Hi, Michelle. That's a very common question that we receive in the office. Now, we understand that if you don't have the capacity, let me backstep a bit. There are actually 4 elements when making a will. So for example, it is like, first of all, you have to have an understanding what it means to make a will. Like, you have to understand that a document is created by you to give your stuff away to whomever. There's also an understanding of, you have to have an understanding of your own property. That includes, like, not only your house, but, your personal property, such as bank accounts and, furniture and all that, like, and antiques. Another thing is to have an understanding with the relationship of the persons that could potentially inherit part of your estate. For example, this person would have to know that, yes, I'm giving my 1922 Indian motorcycle to X person as a gift when I pass away. They have to understand that they're giving away their property when they pass away. And finally, they have to have an understanding of the potential claims that people may have against their estate. Like, for example, if a person with disabilities or does not give a brother or a sister a gift from their estate, there's that potentiality that that brother or sister could make a claim to say that, you know, I'm an heir to potential heir to this estate, you know, and then go through the courts. But in the end, if the person does not have the capacity to understand those four elements, then unfortunately they cannot make a will. And unfortunately, there's really no other alternative other than the table of succession. So the table of succession means that, for example, if a person has passed away, then we look at the person's, you know, the person's, so for example, I've passed away, and then I've passed away with no will. So I've died intestate. It means dying without a will. So basically what the table of succession will do is that they'll say, okay, let's look at the closest living relatives. Did I have children? No. So then basically what happens is, okay, we'll go to my parents. Are my parents still alive to inherit my estate? No. Okay, then we go to my brothers and sisters, and then to nieces and nephews, and eventually so on and so forth. And that's usually how and it's usually how the it's usually how it goes. And if a person has died intestate and has no living relatives, no like whatsoever, the family lines are gone, then basically in the rare case the estate will go to the government. But there is always a relative around that should be able to inherit the estate.
Our next question is for Ken. It's from Marcella. Her question is, my son has MS. What kind of help could I get besides financial, such as a wheelchair or having help driving to appointments?
Both of those. The adaptive devices, assistive devices, program is separate from ODSP. Anyone can avail themselves of it, but if you're on ODSP, it's slightly easier. And what the assistive devices program does is every 5 years it can pay up to 3/4 of the cost, for example, of a wheelchair, a power chair, or other devices, lifting equipment, you know, various things. As far as transportation services, ODSP will pay for transportation if you have a certain number of doctor's visits a month. You'll get a transportation supplement, and of course, there's paratranspo. Not that it's reliable. I'd like a current bit of feedback from people that are using paratranspo in Ottawa now, when they have a moment, because of course it used to be completely abysmal, and there's no reason for it, but perhaps it's better now. As far as other transportation services, supports and so on, I don't believe that any of that is covered. Well, passport funding is only if there are intellectual disabilities. So with MS, you know, one wouldn't expect that, perhaps until even the most latest stage. You could contact your LIN, local health network, to see if you can get any kind of independently managed funding for that sort of service. But there's no question that there's a shortage of supports for these kinds of things.
Since you had mentioned Lynn, there was a question from Maggie for Diane. Her question is, in order for me to manage funds for nursing from the Lynn, they are asking me to get property of guardianship. Is this true?
Hi, Maggie. So we do have a few clients who are pursuing guardianship because they have funding from Lynn, and a prerequisite of getting this funding is to get guardianship. So in their case, yes, it is true. You know, let's discuss this further though. So, you know, feel free to give me a shout. My email is Diane, DIANNE @kpopelaw.ca.
This next question is for Ken, and it's from Sylvia. How important is it to have an account or financial analyst for the estate of a disabled person?
Well, aside from an RDSP, where you definitely need a financial advisor, most people with disabilities don't have substantial assets, although they could, of course. There's no reason they couldn't. And if that's the case, if they're competent and they have an estate personal estate that needs to be managed, and they're not an ODSP, for example. Well, people with disabilities are just like everybody else. They should get proper financial advice. But if they are on ODSP, they're still just like everybody else, except that they don't normally have much in the way of assets. But people will inherit money, and it might be less than would disqualify them. I mean, we do asset exemptions, inheritance exemptions for between, well, any number, but let's just say $80,000 and $750,000. We're working on one that's about $1 million. Takes a bit more creativity, but there are ways to protect the money, and that's doable as long as the person who has inherited the money has the insight to realize that they need assistance and support to protect their newfound inheritance or asset. We have one young fellow, he's in his mid-30s. He has a few mental health issues, and he acknowledges them. He has insight into that. And he won 400 grand on a lottery. So of course we had to hustle to exempt it in different ways, and we did various life-improving things with it. When you plan with this money, you have to keep two things in mind. One is exempting it, okay. But the other is, what about the short-term, mid-term, and long-term plan for that exempted asset? What's it going to be used for? How long are you going to keep it? How much is it? What do you want to use some of it for in the short term? But since it's not a great deal of money, what modest things are you going to do with some of that money that would make your life a little bit better, but that leaves some money later for emergencies? And even if it's a sizable amount, you still have to have a proper, even more so perhaps, you have to have a proper plan for that money. It's amazing how many people acquire new friends with great ideas when they let it out that they've acquired some money. So it's always a very interesting discussion.
This next question is for Diane, and it's from Joanne. Her question is, my child is 18 years old and has the comprehension of a 1 to 3-year-old. The bank is asking for her signature. What advice do you have?
Hi, Joanne. So a lot of our clients run into this problem, unfortunately. Sometimes it's not a problem that they experience right away. Sometimes it's after years of dealing with the same institution, but then maybe management changes. There's a new worker, and they show up to the bank and they've done what they've always done, and now this person is asking them for more information that they're not used to. If we can get around it, we'll try, but usually the answer is guardianship. It doesn't sound to me that your child could do a power of attorney, so it would have to be guardianship.
And I'll just jump in for a sec too, okay? What's happening here is quite often the bank is asking for something that you would normally ask for, but in this case can't be provided, and they just don't know any better. Can I answer a question that's been typed in here, Victoria?
Yep.
Mark has asked 2 questions. If it is unknown what a child's ability will be at 18 or later, does it make sense with limited capital, right, to invest in an RESP, and then when the child turns 18 and they may not be able to access the RESP, convert the RESP funds to an RDSP? Is this even possible? Yes, this is a very workable scenario because you don't know and you have the best of hopes, most hopes and wishes. So go ahead, set up the RESP, make your contributions, get the modest matching grant, the $500 grant. And then when the child turns 18, if it turns out that they won't be able to access any kind at all of post-secondary program, keeping in mind that you can keep an RESP until the child's 35, and that there are new what are called CICE, community integration through college education, sort of geared to the person programs at a lot of the colleges, which don't lead to a diploma or a degree, but they are post-secondary. It's an organized way to do what my clients have done in the past in an ad hoc way. And that is, you find out what the child's interests are, and then you find programs at the college that they can take part in, which is post-secondary, right? Because you're also going to be dealing with the post-age 18, post-age 21 issue where they can't stay in school anymore. Now what? So you could well find it in lots of cases, you could find a use for the RESP, but if not, and that, of course, it comes down to that, then it's clear. Then what you do is, well, in practice, I'll tell you in practice what I recommend. And that is that since the RESP belongs to the owner contributor, the parent, just take it all back. And yes, it's true that you'll lose the grant portion. And yes, it's true that the income growth portion is taxable. That's true. Of course, you could always throw that amount into your RRSP if you wish to shelter it further. And it is true that you could roll that money over into an RDSP so that the income portion does not come into your hands. You could do the paperwork involved with that. But what you do is judiciously look at your options here and how much tax you would pay, and just decide whether to just draw it all back out. And then over time, contribute it to the RDSP. You wouldn't lump sum it because, of course, you only get the matching grants and bonds based upon the $1,500 a year. So suppose you had, well, let's just say 30,000 net from what had accumulated to be a $50,000 RESP. Okay, so now you got 30 grand. You pay a little bit of taxes. Okay, but now you've got the money. Well, you don't lump it in. You just take 1,500 a year times 20 years and use that money to get 90,000. And that speaks to another question that a person asked about setting up an RDSP when the child is young, and should you contribute when they're young? You can do. And if your household income is less than 95,000, then you'll get the full 3,500 grant in return for 1,500. That's good. You wouldn't get the bond because the bond is lost at a much lower level. But otherwise, just wait till the child's 18 and then contribute for 20 years and you'll get all the money. And you'll get the maximum grants and bonds. And if you invest it wisely at 5%, it'll be 700,000 by the time the child's 60. So, you know, if you're trying to pick up, like it finally dawns on you when the child's 14 that maybe you should start contributing because you'll get 3,500 a year. Yeah, sure, go ahead. But in a lot of other cases, best that happens is you put in 1,000, you get 1,000 until the child turns 18. And then based upon his or her income, you get the full grants and bonds. So it's just a tactical, practical sort of thing to consider. And that's my advice. Set it up, get on the list. If grandma gives the child Christmas money, well, okay, maybe put that in. But my experience is that for the most of my clients, when the children are under 18, before they're receiving ODSP, they've got a place for that money, right? There's other uses that year, that month, for that $1,500. I'm done.
All right, our next question is for Diane. This one is from Salma. Her question is, my son was just approved under DSO guidelines. What is available to him?
Hi, Salma. So my general answer to that is I would like you to fill out the short questionnaire that we have on our website. It's called a family evaluation form. And then from there, we can better assess what other things he should be entitled to.
Yeah, we can't really answer that without knowing something about the child.
All right, we have another question for Diane from Billy Joanne. Her question is, I received an inheritance from my dad and I don't want to spend it. What should I do with it?
I don't blame you. You want to keep it, as much as possible. That is also a very good question. Again, the best way for me to answer this, or for any one of us to answer this, is for you to fill out our short questionnaire on our website. Then we can book an appointment and see what your options are.
This next question is for Jennifer, and it's from Sylvia. Her question is, does everyone's will need to say the same thing if leaving money for a disabled person?
Oops. Hi, Sylvia. Basically, there would be wording provided to, so what would happen is that if you drafted a will with a Henson Trust provision in it, what would happen is that the lawyer who drafted the will would also send wording to anyone who wishes to make a gift to the Henson Trust. It would be along the line similar to, if X person survives me 30 clear days, then I leave X gift to the person's Henson Trust for their benefit, not directly to them, but for their benefit in the Henson Trust in the last will and testaments of Sylvie. So that's the wording that is provided to people for other wills and stuff like that. And usually this wording comes into play after you have passed away. Henson Trusts don't receive living gifts. They only receive the Henson Trust only receives testamentary gifts in the will. I'm complete.
This next question is for Ken, and it's from Connie. Her question is, my mother is on ODSP and recently turned 65. She also receives OAS and CPP. How will this income affect her?
Well, there's a bit of confusion here, but that's understandable. What happens is, under the present procedures with ODSP, they have on file your mom's age. And so just recently, the last couple of years, the year before age 65, they have started sending a letter telling people to apply now for OAS and GIS. They won't cut off the ODSP until they're informed that OAS GIS is being received, but you don't get both. So if your mother is receiving ODSP, just because she hasn't notified them of the OAS GIS yet, no harm done. She just didn't know to tell them on a timely basis. It's no evil intent here, but there may well be some kind of overpayment if she has continued to receive ODSP after starting to receive OAS GIS, and she'll have to either pay it back, or what they'll do is they'll send that amount to what's called the overpayment recovery unit, because now she's not on ODSP. And what they'll do is they'll send it to CRA, and any free amounts of money that she might get, the so-called carbon tax rebate and Trillium and all that stuff, it's about $900 a year. That would be held by CRA and sent to ODSP, to the overpayment recovery unit. But that's the worst that would happen. And OAS GIS is more than ODSP. The OAS is about 7,000 and the GIS is about 11,000. So that's 18 compared to about 14,000 for ODSP. So it's slightly more. And of course, then she's a senior, so she gets the Ontario drug benefit for seniors. So all of her drugs are covered. It's all the same formulary as provided by ODSP. And there's a $4 dispensing fee. So that's okay. Depends on whatever other supplements perhaps she might have had. She won't get those. So overall, it's an improvement. The only factor to keep in mind here is that if your mother comes into some inheritance after she's after she's 65, the income earned on that inheritance, let's just say simplistically, that her parent passes on and she inherits 100,000, just for example. If she invests it at 4%, then the $4,000 earned would offset $2,000 of the guaranteed income supplement. So it's basically a 50% tax either way you cut it. It's a 50% tax on the poor, let's put it that way. I'm done.
All right, this next question is for Diane, and it's from Jennifer. Her question is, how do we get guardianship started for our 16-year-old son?
Sorry, I didn't realize I was on mute. So that's a good question, Jennifer. In order for us to file guardianship, your son has to be 18. But in the meantime, what we can do is start the paperwork right now so that when he does turn 18, it'll be an expedited process.
All right, thank you, Diane. This next question is for Jennifer, and I know this is a very common question that we get. It's from Lise. Her question is, what happens if I die without a will?
What happens if when you die without a will, it is called dying intestate, meaning you die without a valid will. So what happens is, like I said, the table of succession does come in. Right now, first of all, what would happen is that a certificate would be applied for probate and for a certificate for a estate trustee without a will. If you have family members living, they can apply for that. And then once they are approved to be the estate trustee, they can start dividing your estate, in equal shares to any siblings that you have. But if you died with no siblings, no family, then what happens is that, yes, there will be a search for families through the table of succession. Like if you had a sixth cousin, like 9 times removed, they could potentially inherit your estate. However, if there's no one to leave your your property and your estate to, then eventually it will go to the crown. Now, but that, of course, that being said, that's in an easy, no contest sort of way. If there is siblings that could potentially contest the will, then that becomes a litigation matter, and which means that would have to be sorted out by a litigation lawyer. I'm done.
All right, our next question is for Ken, and this one is from Rick and Judy. Their question was about buying and selling a house if you have a Henson Trust.
Well, one use of a Henson Trust is to own a home for a child beneficiary, an adult child. And if that child, if the trust purchases this home with a share of its assets, it's perfectly legitimate. Very good use. Of course, you have to carry the home and it has to be suitable to the beneficiary and all that, but that can be the case because suitable safe shelter is a big thing. If the beneficiary who normally resides in the home qualifies for the disability tax credit, then the home can elect to be a principal residence for capital gains exemption purposes, which is very nice. So that means that if you buy this property and it appreciates over decades, and then the beneficiary passes on, under today's rules, if it was sold, it would be sold tax-free. And if this were this type of scenario, even if the beneficiary is not approved for the disability credit and the property is not elected or deemed to be a principal residence, aside from that factor, if the child happens to marry, then it wouldn't be a matrimonial residence divisible with the spouse because it's a trust-owned asset. It's not owned by the child. So it's protection against a matrimonial division. That's pretty good. I think those things can happen to everybody. And then also, it could be an extremely useful intergenerational investment, because what happens is when the beneficiary, let's just say that they're the eldest child, and so then they pass on prior to their siblings, or perhaps the siblings have predeceased, let's just say. Well, what happens normally in those trusts is that the trust residue is distributed after the sale of the home and any other liquid assets to the siblings, or if they're predeceased, to their children, if any. So it's not like the money's lost by giving it to the trust for your one child, even if it's a disproportionate amount. It's really just a sort of a deferred inheritance for the others, and it could be a very prudent, tax-efficient way to pass a substantial amount of money down through the generations. That's it.
All right, our next question is again for Ken. This one is from Debbie. Her question is, what happens when the beneficiary of an RDSP dies? What are the steps that have to happen?
Well, if they have a will, then the contributions that the parents have made, the contributions that have been made, and any growth and any vested grants and bonds are payable to his estate, and that's his estate. It could be substantial. You can see that. If there's a will, then it goes as per the will, but keeping in mind that by definition, to have an RDSP, you have to qualify for the disability tax credit. You're going to find that a number of people who qualify for the disability credit are not competent. So they don't have a will. So then that brings us all back to Jennifer and the intestacy and succession law. And so it passes down either firstly to the parents if they're surviving. We have had that occur. Or to the siblings, if any, or if there were siblings, to their children. And if none of those, then technically what it does is it goes up the line. Well, anybody who wants the tree for succession law, just send me a short note and I'll send you the tree. And goes up the line and potentially could go to aunts and uncles, but if the parents are deceased, if they were the very youngest of all the kids, well, the others are all dead, all the aunts and uncles. So it would go up and over and down to the cousins. And the interesting thing I've always thought is all of these cousins of this not competent kid with disabilities, they may or may not have ever provided any support or even visited that cousin. But then they're the ones that receive the money. So it's unfortunate that that's how it works out, but it does sometimes work out that way. That's it.
All right, this next question is for Diane. It's from Judy. Her question is, does a family member who manages a Henson Trust for a relative need a legal guardianship when the parents are gone?
Hi, Judy. The answer is simple. That is no.
Short and sweet. That's great. Can I just jump in on something that no one has asked about yet?
Mm-hmm.
Well, this isn't an everyday thing. It's not on the list, but I'd just like to make sure that people that are watching are aware of something. You can understand that in Ontario's population, there are a lot of teachers. I don't know, is it 1 for every 30 school-aged kids? And there's a lot of municipal employees, lots and lots of municipal employees. There are firemen, firefighters who would have an OMERS pension. There's hydro, OPG pensions, Ontario Power Generator. There's WSIB, workman's comp pensions. OPP, did I say OPP? So all of those people, there's many within that group, right? It's a large number. And we know that 1 in 10, statistically, has a child with special needs. We know this, right? So of those hundreds of thousands of families, 1 in 10 has a child with special needs. Well, they all have what are called provincial statutory pensions. And provincial statutory pensions in Ontario and the other provinces potentially have an adult dependent survivor pension for the child, the adult child. So the firefighter dies, the spouse receives a proportion of that pension, then the spouse dies, and the child potentially can receive half of the original pension. Now, they have to be an adult dependent survivor, and you can't really prove this until after the second death, but you can start the groundwork. You can get the pension people to know about your child. And there is some paperwork you can submit in advance. Just as of recently, the plans have recently come into an awareness of the situation. So if you didn't happen to know about that, like for example, if you're a teacher, and suppose you're married to a teacher, but suppose you're not, and you have a pension of $60,000, and your husband has predeceased you, and you have an adult dependent child, perhaps they still live with you. so clearly they're an adult dependent child, well, they stand to get 50% of your $60,000. However, they're not competent. So of course, someone has to be their legal representative, such as a legal guardian, to apply for and manage the pension, which of course will displace ODSP. You don't get both ODSP plus the $30,000. But now you have a situation where the child has a $30,000 pension and a $700,000 RDSP, which then proceeds to give them a further $30,000 a year once they turn 60. This has never happened before. Demographically, these pensions for children for teachers have been in place since 1990. But of course, many teachers don't know about it. I was just doing some back checking on OPP pensions the other day, and they're backdated to 2007. So who knew? And in a lot of cases, for example, if a child is severely autistic and is supported living with some residents, their needs are extremely modest. So they have this $30,000 pension. Some amount of that is going to have to be paid to Carrie's place to continue to keep the child, because of course ODSP is lost. But a large chunk of it is never going to be needed by that boy, and it'll accumulate for an estimated lifespan of another 20 years. Let's say he's 54 and mom is 84, right? Mom passes on. So then his sister, who is his legal guardian, manages this pension, accumulates what's not needed, and it grows and grows. And 20 years later, he passes on with no will, intestate, and his sister, his only sibling, receives all that money from both the accumulated non-spent pension money and any money left in the RDSP. This has never happened before. I'm done.
All right, our next question is for Ken. This one's from Joanne. Her question is, what options exist for housing for people with disabilities?
Well, that's as varied as the individual, right? That said, nothing is going to happen for your child's housing for shelter if they're living with you, which often, when this person asks this question, the child is living with them, because obviously the transition hasn't been made yet. Otherwise, they wouldn't be asking about what the options are. So the child is still living with Joanne. Well, what happens is they're on a list, okay, sure, a housing list, but they're not going anywhere until there's a crisis, meaning Joanne dies, or some crisis is manufactured or does occur, such as a divorce and sale of the home and the parties moving, and some crisis like this. But as long as the child is safely provided for at home, they're not going anywhere. And then when the parent dies, okay, so they're on a list. They'll be put into some respite situation, and then a place will be found for them. Whether it's the place you'd like, that's another matter. So that's on the subsidized side of it. On the private solution side, there's lots of options. There's discussion about setting the child up if they're capable in their own apartment, subsidizing the apartment. The Henson Trust could continue to do that, no problem at all. Providing in-home supports for the child. There's always been lots of talk of families coming together and having one of the parents, one of the families keeping the family home in a trust, and having two other similar children living together in the home. That kind of option, that's feasible. There are some special, we've done a couple of housing webcasts about this, about different options. The one thing that typically does not work is what you might think would be feasible, but isn't really. And that is saying, oh, well, what I'll do is I'll leave my home to community living, or, I'm just picking a service provider. I'll leave my home to community living on the basis that they'll continue to support my two boys in the home, and they can have others in the home too. Well, as a rule, the support organizations aren't really interested in the bricks and mortar. They might accept a charitable donation of a home, sure, but the problem is that That's not where the big money is. It's the continued support money, the $60,000 a year that is needed to support those two boys. Well, they can't just arbitrarily take money from their budget and allocate it to those boys. They have to get funding for those boys. And that's a tough hustle. But if you start early, you just might, in some cases, be able to make something like that work. It's possible. It depends largely, in my experience over the years, in how entrepreneurial the executive director of that particular group is, or how businesslike and entrepreneurial the board is. Some executive directors are extremely entrepreneurial, and they see an opportunity, they move, they take it, they're ready. And for others, oh, well, that's not in my job description, it's just more work. I'm fine, thanks. I'm not accountable to the families anyway. They're not on my board, and they don't pay my bills. You know, so there's the two types of executive directors that you'll find, and you have to sort of suss them out and see if you can find one that is prepared to be creative and aggressive, or not. I'm done.
All right, this next question, this one is for you, Ken. It's from Robert. This question is, what steps can be taken to extend the trust beyond 21 years from the date of the gift giver's death in a Henson Trust?
Thanks, I appreciate that, Robert. That's a fallacy that's widespread. The whole point of a trust is that it doesn't die, it doesn't potentially ever die. And that's why there are rules against perpetuities in some provinces. In some cases, they've been removed. But the 21-year rules that you're thinking of don't deal with the lifespan of the trust. That's just not the case. Although there is normally an expiry of the trust, a liquidation of the trust, typically upon the death of the beneficiary. But you can see that it could be a family wealth trust, and that could well be a Henson Trust too, because you never know if any of the kids will have disabilities, right, for one. But you could have a trust that is set up today and lasts for 3 or 4 generations and then is distributed. So clearly it's not 21 years. I know of one trust that it's now been distributed, but it was set up in the 1850s from the money made logging the valley. And that was just as of about 10 years ago. So you can see they're very long lived. But the two 21-year rules, the one is the provincial accumulation rule dealing with the accumulation of income undistributed. You can't accumulate undistributed income for more than 21 years in Ontario. You have to then start to distribute it. But of course, it's already been distributed in most cases. You don't use it to purely hold all the income for 21 years. That's very unlikely, wouldn't you think? And the other is that the federal deemed disposition rule, and that is that if the trust owns a capital asset, whether it be stock or rental properties or whatever, every 21 years, the trust is deemed to have disposed of it. So the worst that happens, for example, is that there's a triplex, a rental property triplex owned by the trust, and the net revenue from this rental property is used to fund the trust and to fund the home occupied by the beneficiary. You can see how that scenario would be logical in certain cases. I have a family up the valley who, when they came to me, their 3 girls with special needs were quite young, but the plan was to have the rental properties that they owned across the street fund the home for the children. This is one housing alternative that they planned ever since the kids were very young, and it's perfectly workable. But what happens, of course, is that once the parents die and the trust owns the rental properties, 21 years later, the trust is deemed to dispose of them. And so say, let's just for simplicity, they bought it for $200,000 and now it's worth $400,000, just for simplicity. So there's a $200,000 capital gain deemed to be triggered every 21 years. Now, of that $200,000 capital gain, $100,000 under today's rules, $100,000 is taxable. So what happens is you have this adjusted cost base of $200,000, a fair market value of $400,000 after 21 years. This is purely numbers, right? You have a capital gain of $200,000, half of which is taxable. So that's $100,000 income deemed to be income to the trust. And of course, if this money is taxed in the hands of the trust under today's rules since 2016. It's taxed at the top marginal rate of 50%. So the trust owes $50,000 in taxes. But that's the worst. So it has to then mortgage that $400,000 property, which is now tax-free because you've been paying off the mortgage over the last 21 years. Mortgage-free, sorry. Or of course you can attribute that income to the children and pay no tax, in this case 3 children. So they each have a personal tax credit of $13,229 and the disability credit of $8,400. So about $21,000 of tax credits each. So $63,000 of the $100,000 taxable is not taxed. And then the balance of it, the 40,000, roughly 31,000, is taxed at 22%, so about $8,000. So you've got this deemed disposition, which under these kinds of scenarios results in taxation of $8,000. I think we can handle that. I'm done.
All right, this next question is for Diane. It's from Raymond. His question is, a friend passed away without a will or next of kin. He named me as a power of attorney before he passed. What's next?
Hi, that's a very good question. Well, the first thing you should know is that your power of attorney is no longer valid. A power of attorney, that appointment terminates when the person who appointed you passes away. Now, if your friend passes away without a will, what we have to decide is, is probate necessary in order to get control of the estate, and who will be applying? Those are the two main introductory questions. But then, we'd have to have another further discussion to see what else your friend might need.
Can I jump in on a question on the screen here? Mark is asking, is this true? This is the pension question. Is this true of Government of Canada employee pensions? No, it's purely provincial. And not all provincial. For example, nurses' pensions, hoop pensions don't have this. Okay.
All right, and then I have a question for Ken from Scott. His question is, upon the death of both parents, can an RRSP balance be transferred to a disabled child without a tax penalty?
That, of course, depends on a few factors. These are simplistic questions I'll try to answer. And we only have about 4 or 5 minutes left here. It's 1:11, so we'll try to wrap up at 1:15. I see we have 109 people still online, so there's been a slight waning of interest, but that's understandable. You can leave an RRSP directly to a person who has cognitive impairments, but they have to have a cognitive impairment to roll it over like you would to a spouse. And of course, if it all exceeds 140,000, well, then it would affect their ODSP, cut them off. But yes, you could. Then you'd get into the question of, well, if they have a cognitive impairment, are they competent? So then, of course, do you have to have a legal guardian to make certain elections? Well, yes, you do. But if they're competent to sign powers of attorney, but otherwise they have competence questions, then you could roll it to them personally, but affect ODSP. Or if a person has an RDSP, regardless of cognitive impairments, they could receive and contribute up to nominally $200,000. That's the limit. Now, of course, if you've set this up when the child's under 49, then what happens is you've probably only got a $170,000 room left. And as I said to one client whose plan was to leave his $150,000 RRSP or RIF to his son to then put into an RDSP, well, he's 54, so you'll have to die before he's 59. And if you do, great, then your plan will work. And if it doesn't, come and see me. So maybe it's not as funny as I thought it was at the time. And then if you happen to have a much larger RIF, like $200,000, $500,000, $800,000, then the thing to consider is what's called a lifetime benefit trust, which is specifically designed to receive registered funds. But here too, the beneficiary has to have cognitive impairments. It's just that if you leave this larger sum to the lifetime benefit trust, it does roll over, certain procedures for using it and so on. But what it means is that it doesn't affect ODSP, because the asset won't affect it, just like a Henson Trust won't affect it. And you still have to deal with the disbursements for ODSP purposes, but basically the tax savings are substantial. Obviously, if you die, we have examples here. I'll just show you one briefly. You can see here, when you get these slides, you can take another look. If you have a $500,000 RIF and you die tomorrow, you die in December, you get all your other annual income. And let's just say for simplicity that you're taxed at 50%. So you pay tax of 250 grand. Well, if instead you go through the procedure with a lifetime benefit trust, then the child gets basically annuity payments of about 25 grand a year, or the trust gets them actually, and then distributes them. But you declare that income in the hands of the child. And as a result, only 3 grand is taxable, because you're using their credits, as I mentioned with the 3 girls. And so the taxes that you actually pay are very, very small, $780 a year. And what you do here is you build in the annuity, as I mentioned, a payback period guarantee, so that all of the money, all the 500,000, is paid back either to the child while alive or to someone else when they're deceased within the guarantee period, which in this case is 20 years. And that means that over those 20 years, the taxes you pay are 14,000 compared to 250,000. So those are your choices, directly to the person, but it could affect ODSP, a limited amount, but maybe sufficient, into an RDSP, but prior to age 59 for the child, and otherwise into a lifetime benefit trust. Now, I think that brings us to the end. It's 1:15. I think we've done a great job. I hope that you think so too. We've had lots of questions. Karen, how many do you think you answered this time? You thought you did, how many did you do last night?
Oh, I can't remember, close to 100, but these are about 70.
Oh, that's not too bad. I mean, we had 100 and, what was it?
There's 103 right now still on.
We had 125, I think, at the high point here.
I believe so. There's a few questions left. A lot of them are about RDSPs and such. Unfortunately, I couldn't answer everybody's.
Well, here, for the viewers here are the email addresses. For tax matters, you can email Victoria or Karen. For guardianship matters, Diane. For will and trust matters, Jennifer. For benefit increase matters, where'd you go, Karen. I'm happy to answer questions as well, but normally what happens is they sort of get filtered through the team. Everybody specializes in one or two particular areas. And if it then is something that they want to collaborate on between themselves or with me, then they bring it to a discussion and we give a better answer. But as Diane has said a couple of times, we're pulling straws here. Unless we have the family details form, we don't really know enough to properly give even close to the right answer. In a lot of cases, we can simply cite the options, as I just did with the registered fund options. There's 3 options. Well, which one's suitable for you? I don't know, because I don't know enough about the situation. So if a person wants, some kind of real answer, then we need that information. So that being said, I'd like to thank everyone for taking part. I'd like to thank the team for taking part. I think you did a great job. And I'm going to close off the session now and all going to go and get some lunch.
And can I say one quick thing?
Sure.
A lot of people are asking for copies of this presentation and slides. Within a couple of days, we'll send out a copy.
Yeah, everybody gets the video and the slides. Everybody who registered gets it. And you're welcome to pass it on to others. We're not trying to restrict it. It's not secret. That said, thank you very much.
Thank you.
Thank you.